Hi, I'm Sonny Virk. I'm Senior Counsel here at Virk Barristers. We're a criminal defense firm based in the Toronto area. Today, I'd like to speak to you a little bit about driving-related charges while under the influence of either alcohol or drugs. Now, there are many types of charges that could result if you're found in circumstances where you're driving under the influence of alcohol or drugs. There are 4 types that I'd like to speak to you about today. The first type is over 80 or excess blood alcohol. You're required to provide a sample of your breath into a breath machine at the station. In fact, you're required to provide 2 samples about 20 minutes apart. If those samples are found to be over 80, meaning over 80 milligrams of alcohol in 100 milliliters of blood, you will be charged with this offense. The second type of charge is impaired driving. It has nothing to do with blowing into a device. It has to do with whether you look or act drunk enough. If an officer has reasonable and probable grounds that you have enough of the indicators, you will be charged with this offense. Some examples are slurred speech, odor of alcohol, the manner of your driving, whether you're weaving all over the road. And one more would be, for example, your motor skills. You have trouble getting out of the car, you have trouble walking. These types of things, you could be found yourself convicted of impaired driving. The third offense is care or control. This one comes as a surprise to a lot of people. If you're not even driving and you're in a car and you're sleeping, but in the driver's seat, and it's determined later on that you had excess blood alcohol or you had enough of the indicators of impaired driving, you could be convicted of this offense of care or control. If you're found in the driver's seat, it is a rebuttable presumption, meaning if you can demonstrate to the court that you weren't going to drive, then you could find yourself getting yourself out of this charge. Another example of this is if your car falls into a ditch and you're not even in the car, but you're near the car, you could again find yourself with this type of charge. The last charge is refuse, and it's exactly how it sounds. If you refuse to provide a sample of your breath when legally required to do so, there is a presumption that your blood alcohol level was over 80. Again, it's rebuttable, and if you can present evidence to the court that you had a legal excuse for that, then you may be able to get yourself out of this particular charge. As you can see, these are very technical in nature, and our firm deals with a lot of these types of charges, and it's important to consult with a good criminal lawyer, or feel free to contact our office if you have any questions relating to these types of charges. That's all I have for today. See you next time. Thanks.